Good morning, students. Hope you all are fine and good. So today's chapter is Unit 2, that is Forms of Business Organization. In that we're just seeing Chapter 6 of Joint Stock Company. So I remember that I have already started this lesson and half of the lesson is already completed. So we'll just go for a quick revision. Okay, it is like we saw meaning, definition, then we just went with the characteristics, then advantages, disadvantages we saw, and then we saw the types of company, isn't it? So see, the types of companies, we just finished the classifications of company on the basis of incorporation. So we saw three different companies, that is chartered company we saw, then we saw statutory company and company association not for profit. So these three types of company we even saw in this subcategory. Okay, so the next one that we have is a classification of company on the basis of membership. It's very simple, isn't it? With the name we can understand. It's only in the number of members. Based on the number of members, the companies have been categorized. Like how? Let's see. The first one, private limited company, is a type of a company which is formed with a minimum 2 shareholders and 2 directors. The minimum requirement with respect to authorized or paid up capital is of rupees 1 lakh, has been omitted by the Companies Amendment Act of 2015 with effect from 29th of May 2015. Another crucial condition of a private limited company is that it by its articles of association restricts the right to transfer its shares and also prohibits any invitation to the public to subscribe for any securities of the company. Maximum of 200 persons can become the members in a private company. The name of the private company should be suffixed with private limited or LTD, that is limited. Okay, example, Scientific Publishing Services Private Limited. Can you see the name there? A Scientific Publishing Services Private Limited, that is in Chennai. A private limited company can be formed in 3 variations. So before we go to the next paragraph, I'll just explain this first. Private limited company is nothing but a type of company which is formed minimum of 2 members. Okay, the minimum members in a private company is 2 members. The maximum of a private limited company as of now, it is 200. Previously it was only 50, but now it is 200. Okay, so that is as per the amendment. It is already mentioned. It is according to the 2015. Your maximum number in a private company is 200 persons. Okay, so you can have 2 shareholders, that is minimum members, and 2 directors will be there in a private limited company. And one of the most important thing is private company can be identified with the term, that is the name will be followed with LTD or limited terms. Okay, so that is what is the private limited company. So as a private limited company, as a small private limited company, as a 1-person company, like very simple, it has been categorized as 3. So as a private limited company is the first category. The next one is as a small private limited company, only few members will be there, that is a small private limited company. And next one is as a 1-person company. Even these are the 3 categories that we have. So we are not going to see in the detail about all this. Okay, just know what is private limited company, that's enough. Okay, so public company. What is public company? Public company means a company is not a private company. Very simple, isn't it? If it's a public company, it won't be a private company, right? So the minimum members will be around, minimum is 7. So there we saw private limited company, it is minimum is 2 members. Here it is minimum is 7 members should be there to start the company. That is the maximum limit will be unlimited. You don't have any numbers for it. You can have how many members you can have, you can just have it on. Okay, that is what has a minimum paid up capital of 5 lakh or such higher paid up capital as may be prescribed. So it should be more than 5 lakh. If it is a public company, then it should be more than 5 lakh paid up capital should be there for a minimum case. Okay, is a subsidiary of the company which is not a private company. Does not restrict the right of shares. Very simple this is, isn't it? So there in a private company, the transfer of the shares are restricted. It means if from one member to the next member, if you want to give the share to some other person, you can't do it in a case of a private company. But the shares are very easily transferable. That is only in the case of a public company. Okay, not in the case of private company. See, does not prohibit any invitation to subscribe for any shares or debenture of the company. Does not prohibit, it means it will not prohibit for invitation invitation of subscription from any of the shares or debentures of the company. It will not do that. It will not prohibit it. It will not stop it. Okay, does not prohibit an invitation. It means even the shares are even invited to the public, general public, and then only we are inviting the invitations are subscribed to the shareholders, and we are getting the shares. That is what. Okay, it will not stop it off. It means we have the option. In private company only it will prohibit. Here it is not prohibiting. It means we can issue it through the public. Okay, that is what. It will invite the investors through the public only, by the public issue they will say. Does not prohibit any invitation or acceptance of deposit. So invitation of acceptance and deposits is not being prohibited in this public company. We can do that. That is what. The name of the public limited company should be suffixed with the limited. Example, National Aluminium Company Limited. So very simple it is. If name ends with PVT Limited or private limited, it means private company. If a name of a company ends with only LTD or in the term Limited, it means it is the name followed by limited. It means a public company. Okay. So classifications of company on the basis of liability. So let's go on with this. So we have seen two different types of liability, isn't it? One is limited we saw, and the other one we saw is the unlimited liability. So now let's go on with the company, like what there is to do with this liability in companies. Let's see this. A company limited by share is a company in which the liability of its members is limited by its memorandum to the amount, if any, unpaid on the share respective held by them. It means nothing but, actually if you start a company you need to make two documents. Okay, one is MOA, that is Memorandum of Association. The other one is Article of Association. These two documents plays a major role in creating a new company. Okay, so if you just want to know about the procedures in this, so you'll be learning this in the future chapters, don't worry. But anyhow, just know the name of the document. That is Memorandum of Association is one of the fundamental document. Okay, it's a basic document to just begin to just establish any company. So that is MOA we say. Even in short form we can say MOA. It is very simple that will be mentioned. It seems the liability of the company in this company limited by shares. In MOA itself it will be mentioned. It will be the liability of its members only be limited. Okay, that is what is mentioned here. See, the company is limited by shares may be either public company or a private company. It can even be a public also or a private also. It can be. It is not that public or private and all. Even both can use it off. Okay. So next one, if a member has paid the full amount of shares, then his liability shall be nil. If a member has paid the full amount of shares, it means yes, for example a share value is ₹100 means they'll have some first call, second call, so all. Okay, so all that when they just finish off, first of all they will pay only one partial amount. There will be some amount in the application itself. So in that application, based on that application, they will pay the initial amount. So after that, after a few days, what they will say, they will just you have to pay some 20% or 30% of the full amount of the share. So like that. They will pay slowly they'll pay, and once when they just pay all together, that is ₹100 for each share. So when they just complete their payment, so it means the liability will become nil. Okay, thus two main features of a company limited by shares are as follows. So what are the two main features that they have only in the company limited by shares? What are the two features that they have? First one is the liability of its members is limited to the amount remaining unpaid on the shares held by them. So if they don't pay the amount of the share value completely, then only in that case the liability will exist, otherwise it will not exist. That is the first feature. Next one is such liability can be enforced either during the lifetime of the company or during the winding up of the company. So such liability, so whenever they just wanted to take up this liability, when they want to claim of the money for the creditors, at that case also what will happen, only during the lifetime of the company they can do it. Otherwise even during the end of the winding up of the company also they can do this. So these are the two features that they have for the companies limited by liability. The next one is company limited by guarantee. What is company limited by guarantee? It means a company limited by guarantee is a company in which the liability of its members is limited by its Memorandum of Association to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being bound up. Such companies are generally formed for the promotion of commerce, art, science, religion, clarity, or any other useful object. The company is limited by guarantee may be either private company or a public company. Okay. The company is limited by guarantee is also the same kind of company, like almost the same kind of company that we saw with the company limited by liability of shares. Okay, so let's see with this. So it is nothing but the company in which the liability of its members, in this also the in memorandum itself they will mention the liability is limited. Okay, though what happens is they will guarantee that only if the company is going to face any kind of wound, it means any kind of drawfall. Okay, loss, something like that, where they are just going to go for a wind up. At that case, what happens, only at that time they will contribute the money to the liabilities will be contributed to the creditors. So such kind of such companies are generally formed for the promotion of, so actually these kind of companies are formed for the commerce, art, science, for the welfare issues. They are doing it for the welfare of the economy. Okay, the company is limited by guarantee may be either private company or public company. It can be either private also, or it can be even public also. Okay, the next one that we have is the unlimited company. What is unlimited company? Unlimited company is nothing but unlimited company is a company in which the liability of its members is not limited by its memorandum. In other words, liability of the members is unlimited. There is no limit on the liability of the members. The members of such company may be required to pay company's losses from their personal property also. Very simple, isn't it? So we already know about this unlimited liability. We even saw in this case of a sole trader, a partnership firm, we saw joint to the family system, we saw the Karta's liability will be unlimited, isn't it? So we already know about all this unlimited term. We already we come across such things, isn't it? So like same way in MOA, that is in Memorandum of Association, they will not mention it is the liability is for limited and all. Okay, so at that case what happens is automatically the liability of the members is unlimited only. So they here what happens is, in case if any problem occurs in future, the creditors, if you want to pay the money for the creditors, either they can just pay from the business, and if it is not sufficient, even the personal assets also is responsible for that particular liability. Okay, because such companies have a separate legal entity, its creditors cannot file a suit against the members directly. The creditors will have to apply to the court for the winding up of the company, and then the liquidator will direct the members to contribute to the assets of the company to pay off its liabilities. So here what the case is, we even saw whenever the case is for the unlimited liability, we saw that in case of a partnership or in a sole trading concern, whenever the creditor finds that he is not able to pay from his business, what happens is he will just quickly go back to his personal assets and he will pledge it off, isn't it? But here it doesn't happen because it's a case of a company, right? So what they must do is the creditor should go and file a suit on the court. Okay, the court only will order for paying the debts and all, the liabilities and all. For that reason, then only the personal assets will be taken off and then it will be repaid off. Okay, that is what. Classifications of company on the basis of control. So classifications of company. So how it has been classified and based on the control. Let's see. A public enterprise incorporated under the Indian Company Act of 1956 is called a government company. These companies are owned and managed by a central or a state government. Such that is section 617 of the Companies Act of 1956 defines the government companies as any company in which not less than 51% of the paid up share capital is held by the central government or any of the state government, or partly by the central government or by the and partly by one or more state governments. It's very simple. Before you get this law, before the Indian company, actually initial stages and all, so when we started learning commerce, the companies were only bound for the Indian Company Act. It was the Indian Company Act which was the first act which came for the companies. So it was actually published in the year 1956. Okay, so what happened was later on they found so many changes, and after that it was amended in 2013. So what did they do was, only at that time they just made the changes with the company, and later on only they just added some few changes to it. Some amendments were done. Amendment means nothing but some few clauses will be removed and will be edited and will be added off. Okay, so according to that only the Company Act was just regulating. But though the 1956 Act is active only, but though when we just write in the exam, we will just mention the new act that we have. Okay, see, that is what. So government company means nothing but the company which is actually the paid up share capital will be more than 51% of the paid up share capital will be contributed by the central government or by the state government, or it can even by both the central and the state also. That also can happen. Okay, so these are the conditions for a government company. See, a subsidiary of a government company shall also be treated as a government company. These companies are registered as a private limited company, though their management and their control vest with the government. There is a type of organization where both the government and the private individuals are shareholders. Sometimes these companies are called as a mixed ownership company. Even though if it is contributed by the central government or by the state government, so it shall also be treated as a government company. But these companies are actually registered as private limited companies only, though the management, the control, everything is done by the government also, but it is it is registered like as per the private company only, because this type of organizations are all the government and private also will involve in this. Shareholders will be like government as well as private also. So because of this, even it is called as a mixed ownership company. Okay, that is what which happens in a government company. So see, Steel Authority of India, Indian Oil Corporation, Oil and Natural Gas Corporation, Bharat Heavy Electricals, these are, or we call it as a government company, but both government also will be there, private also will be there. That is why it is called as a mixed ownership company. Okay, next one, holding company means what? As per the section 2 of 87, subsidiary company or a subsidiary in relation to any other company means a company in which a holding company, that is, it controls the composition of the boards of directors or exercises or controls more than 1/2 of the total share capital, either at its own or together with one or more of its subsidiary company. Okay, so the first case, holding company means what? It actually controls the board of directors. Okay, so here it exercises and controls more than half of the total share capital. It means more than the half the share capitals have been controlled by them only. Okay, and so either they will control the half, or else together they will do it with one or more companies they will have. Okay, that is what is called as the holding company. So what we can say, rich people, rich entrepreneurs, they will have so many companies, isn't it? So even they have the shares in different companies. So majority of the share who is going to have, they are called as the they are actually the real owners of the company, isn't it? They will become a member in the board of directors. In that they will even become a member. So like that case, what happens is these companies also, it is called as a holding company means because it is actually holded by so many other people. Likewise, whenever they have the proportion high, then at least half or more than that if they have, then that is called as a holding company. They will even have more than 1 or 2 branches also. Okay, they will have subsidiary company. That is what, provided that such classes or classes of holding companies as may be prescribed shall not have layers of subsidiaries beyond such numbers as may be prescribed. So next one, subsidiary company. Subsidiary company or subsidiary in relation to any other company means a company in which the holding company controls the composition of a board of directors. Subsidiary company means what kind of company is that? It is also called as a subsidiary company. Okay, or subsidiary. So in relation to any other company, like when you just relate with any other company, subsidiary company is a company which means which belongs to a holding company. Actually this kind of company is like I already told you, when an entrepreneur is going to have so many companies, the company which he holds his share more is called as a holding company, and the companies in which he has invested more in some other companies, like same way, that is called as a subsidiary company. Okay, see, that is what the controls composition of a board of directors or even it will exercises or controls more than one half of the total share capital either at its own or together with one or more of its subsidiary companies. So same kind of company holding the shares with different branches. That is what H Limited holds more than 50% of the equity share capital of S Limited. It means now H Limited is the holding company of S Limited and S Limited is a subsidiary company. Can you understand? So H Limited, he is actually holding 50%, and here H Limited is a holding company and the S Limited is a subsidiary company. Next one is classifications of company on the basis of nationality. Very simple, isn't it? It's very clear. Domestic company means the company which will be within our country. The foreign company means the company which will operate in foreign countries. So that is foreign company. Domestic company. A company which cannot be termed as a foreign company under the provisions of the Company Act should be regarded as a domestic company. The company which is not, the company which cannot be termed as a foreign company. The company is not, which and all is not a foreign company, then it means very simple, it is a domestic company, isn't it? The company which operates within our country, that is called as a domestic company. Then the foreign company. The foreign company means a company which is incorporated in a country outside India under the law of that country. After the establishment of the business in India, the following documents must be filed with the Registrar of Companies within 30 days from the date of establishment. So, foreign company also, if you want to establish a company as a foreign company, then even so many procedures are there to be followed as per Indian Company Act. Okay, so based on that, you must follow the terms and conditions. For that, even documents must be filed and it should be registered with the registrar within the 30 days before you start the company. Okay, a certified copy of the charter or statute under which the company is incorporated, or the memorandum, an article of association translated into English. So this should be given. It should be in only English. That certificate should be given. The full address of the registered office of the company should be there. A list of directors and secretaries of the company should be there. The name and address of any person resident of India who is authorized to accept on behalf of the company service of legal process and any notice served on the company. So for that particular company, some person should be their legal person. They are from the hometown, home country. Okay, that name also should be there. The full address of the company's principal place of business, that also should be there. Next one, we have the third one that we have is a multinational company. I think you all know this term very well. MNC, it is also called as MNC. It's nothing but the company which has so many branches outside the country and which is established not in India but in foreign countries. That is called as a multinational company. Okay, it is a huge industrial organization which operates in more than one country, carries out production, marketing and research activities on national scale in those countries, seeks to maximize profits world over. A domestic company or a foreign company can be a MNC also. A domestic company and even a foreign company even a foreign company can even be a MNC also, of course, isn't it? So a company which operates in India, it might be the headquarter, and the company which they want to launch in further countries might be a foreign company. It means it may even be a MNC. So that is, chances are there. That is what. See, so seeks to maximize the profits world over. A domestic company or a foreign company can be MNC. The Microsoft Corporation, Nokia Corporation, Nestle, then Coca-Cola, International Business Machine, PepsiCo, Sony Corporation. See, when you just look into the Google, even you have different terms for the MNCs. The MNCs are also termed as world enterprises, global giant also. The other name which calls for the MNC is global giant. Okay, so we even call it as global giant, world enterprises. Then transnational company we call. So multinational companies also other one. Okay, so these are the different terms which we have for the MNCs only. Even you can find out different terms if you want. You can go for a Google and find out the different terms if you have the anxiety to find out. Next one is the Memorandum of Association. Students, as I already promised you, so now we are going to see about the documents that we have before when you start an organization, before you start any company, what are the documents? I already told you, right? Fundamental documents are there before you just establish a company. So that fundamental one of the first one, the most important one that we have is Memorandum of Association. See the picture over here. Can you see the picture? Like this only the memorandum will look like. Okay, so let's see what are the information which are given. A memorandum of association is a legal document prepared in the formation and registration process of a limited liability. It means what? It is actually a legal document, MOA, already I told you, right? So it is a legal document which is prepared in the formation and registration process of a limited liability company. So the liability of the company will be only limited, and that is kind of the memorandum which is actually formed for the limited liability company to define its relationship with the shareholders. In order to define the relationship with the shareholders, like see, when you start a partnership firm, you just make an agreement that is called as a partnership deed. So when you start a company, so many people are involved in it, isn't it? So your risk is very high over there. So for that reason, you must make so many rules and regulations, isn't it? You must fix all that. Then only you'll be able to run your business in a smooth way. So that is very, very essential and important to just first of all to make the memorandum of association. That is why the rules are made like this. So see, it defines its relationship with the shareholders. It reveals what power it has and what activities a company is permitted to undertake. It's very simple. Memorandum of association, it will just tell you like what is your company name and where is your register office is located, okay, and what kind of objective your company has, either it is service motive or a profit motive, all that is there, and how many members are there in your company, all that will be mentioned in your memorandum of association. Okay, so that is what the basic thing which will be there in your memorandum of association. Okay, any act of the company outside the scope outlined in its memorandum is said to be ultra vires and it is not binded on it, and it is the constitution of the company in its relation to the outside world. It is a public document, and any person dealing with a company is presumed to have sufficient knowledge of it. It is the primary document of a company. Very simple. I already told you one of the primary and fundamental document is memorandum of association, isn't it? This is one of the most important point. So you can even get it for 1 marks. Dash is the primary document of a company. That is memorandum of association is your primary document of your company. See, name clause. Name clause, what are the contents in your memorandum of association? I already told you contents is nothing but what you will have it on your document. That is what, okay? The first one is name clause. Name clause means nothing but your name of your company. Like how it will come. By the so and so, the name will followed by limited, it means public company. If it is a PVT limited, it means a private company, isn't it? So that name will be mentioned in your name clause in your memorandum of association. Situation clause is nothing but your register office, where your register office is located, where you have registered your company, and that address of the register office will be mentioned in your memorandum of association. That clause is this, okay? Object clause means what kind of objective you have, what is your main objective in the business, and whether it is service oriented or a goal oriented or a profit oriented, whatever it is you must mention here, or economy oriented, whatever it is, okay? So that objective should be mentioned here in a objective clause. Liability means what kind of liability you are going to have. If you mention limited liability, your members in the company will have only limited liability. If it's going to be unlimited, if it doesn't mention any, the term limited means, it means automatically it will go for unlimited, isn't it? That we already saw in the types of companies. So your liability, it should be mentioned here, whether limited or unlimited, okay? Capital clause means your capital, how much capital you're going to contribute, with how much you're going to start the company, that should be there. Your minimum value as per the share, like what value you're going to contribute, that should be mentioned there. Then association clause means how many members are going to start the business and how many, basically like how many members are going to be. So see here, the association clause confirms that shareholders bound by the MOA are willingly associating and forming a company. It is required 7 members to sign an MOA for a public company and not less than 2 people for a MOA of a private company. Yeah, of course. We know minimum members in a private company and in a public company. Private it is 2 and maximum is 200, and a public company we saw it is 7. Minimum is 7 and the maximum is unlimited, isn't it? Those minimum members should be there for signing the MOA, okay? The signing must be done in the presence of witness who must also append his signature. So it should be even even the signing should be with the in front of the witness person, okay? That also, witness he should also be there. The next topic is article of association. I already told you 2 documents are required to establish your company. So first one we already saw. So the next one is article of association. Let's see what do we have for the article of association. The article of association is, very simple it is. Basically when you just take a company, a name of a company, like what and all you will see outside a company, what is viewable to the outsiders, and what and all you can just the details which can be showed to the outsiders, that is called as that will be in the memorandum of association. Okay, and the inside tactic will be there, no, the percentage of profit, dividend, all that, though those all will not be revealed to the outsiders. Those kind of thing which should be within the company, that will be only mentioned in your article of association. Okay, all the basic, all the the tactic of the company, the basic information of the company, the basic rules that they must follow, and what are the way, like how they are going to share the dividend, the percentage of dividend, and so all that, everything will be mentioned only in your article of association. So this will not be shown to the outsiders. Okay, it will be only within the shareholders. See the next one. The article of association is a document that contains the purpose of the company as well as the duties and responsibilities of its members. It is an important document which needs to be filed with the register of company. These are the bylaws of the company that defines the mode and the manner in which a company's business is to be carried on. In the Company Act, Table A prescribes model for the article of association, article of the company. The Table A is a document containing rules and regulations for the internal management of the company. See, it contains only the rules and regulations of the internal management of a company. This is what the main point in an article of association. Article of association, it will contain only the basic rules and regulations of the internal management of a company. Okay, so it is very secretly maintained. A company which does not have separate AOA may adopt article. If they don't have any article of association, they can even go with the common as per the Company Act, you have called as a rule is there under Table A Act, so that also they can follow. If they feel that they don't want to follow this, they can just go with that. The contents that they have is amount of shares, how much they have invested, capital, then value and types of share, like what type of share they have, that will be mentioned. The next one is rights of each class of shareholders regarding voting, dividend, return of capital, that should be mentioned. Then rules regarding the issue of shares and debentures should be there. Procedures as well as regulations in the respect of making calls on shares, that also will be mentioned. Manner of transfer of shares is there. Declaration of dividend must be there. Borrowing powers of the company, rules regarding the appointment, remuneration, removal of directors, then procedures for conducting proxy, quorum, meeting, etc. must be there. Procedures concerning keeping of books and audits should be there, and seals of the company, then procedures regarding the winding up of the company. These all info content should be there in your article of association. Okay, so the next one that we have is a prospectus. It is nothing but, according to the section 2 of 36 of the Company Act, any document inviting the public to buy its shares or debentures comes under the definition of the prospectus. It also applies to advertisement inviting deposits from the public. See, can you see this point? It actually invites the public, it will invite the publics to deposit into the shares. It is nothing but like when a company is establishing just giving shares, no, that time what happens is in a newspaper they will give an ad that so and so company is inviting for the shares and dependents, shares and all. Okay, so when you just see it, when you just give this is called as a prospectus. So what a shareholder must do is they must check for this advertisement, and they will just give an application. The application will be given there, they must fill it, and then how to apply and everything will be given on that particular advertisement itself. They must apply and they must get their shares. That is what. Okay, so that is what according to Company Act, what is given for prospectus, that is there. So when you just go for a college or when you just go and join a school, so in order to know about the school, what you will do, you will get the prospectus of the school and you will read, right? Like same way, before investing into any company, you can get your prospectus of that particular company and you can read it and get the knowledge of the company, so that you may know like how you can invest or not. Okay, that is what. Contents. So what are the contents that you will have it in a prospectus? A prospectus is the only window through which a prospective investor can look into the soundness of a company's venture. Hence, it must specify at least the following matters as per Schedule 2. So, what and all should be there in a company, that how they can invest in a company, that everything is mentioned in your prospectus only, and how soundful your organization is, that also is very clearly there in your prospectus. So the following information are there. Prospectus contains the main objective of a company. It actually contains what kind of company it is, what objective of a company, what is the objective of a company, that is there in your prospectus. Name and address of the signatories of the Memorandum of Association and the number of shares held by them, that also is there. Your name, your address of the company is there, your signature in the Memorandum of Association is there, and the number of the shares that are held by them, that also is there in your prospectus. Next one is name, addresses and occupation of the directors and managing directors. That must be there. The name and classes of shares and debentures issued, so that also should be there. The qualification, shares of the directors and the interest of the directors for the promotion of the company, the number, description and the document of the shares and debenture which within the 2 preceding years have been agreed to be issued other than cash. The name and addresses of the vendors of any property acquired by the company and the amount paid or to be paid. Particulars about the directors, secretaries and the treasurers and their remuneration should be there. The amount for the minimum subscription. If a company carrying on business, length of the time of such businesses also should be there. And then the estimated amount of preliminary expenses, name and address of the auditors, bankers and solicitors of the company, time and place where copies of the balance sheets, then profits and loss account and the auditors' reports may be inspected. The auditors' reports so submitted must deal with the profit and loss of the company for each year of 5 financial years immediately preceding the issues of prospectus. So, if any profit or reserve has been capitalized, the particulars of such capitalization will be stated in the prospectus. See, can you see all the contents in a prospectus? The first one, the objectives must be there, and it should be signed also by the MOA, the shareholders in the MOA. Then the name, address and occupation should be there. Then the third point is the number and class of shares, how much shares you have. For debenture shares, that must be mentioned. The qualification shares of directors means like how much qualification, how much shares they must hold to become a director, that must be mentioned. And then the interest for the directors, that also should be there. The number, description and the documents of the shares and debentures within 2 preceding years. So within 2 years, like how many numbers they have got the shares, like what kind of descriptions are given, that should be very clearly given there. The name and address of the vendor of any property acquired by the company and the amount paid or to be paid. So how much money we must pay to them, like how much we have got, that everything must be clearly mentioned. Particulars about the directors, secretaries and the treasurers and their remuneration, like who are the directors, secretaries are there and treasuries that we have, and even the remuneration must be very clearly stated there. The amount for the minimum subscription should be there. If a company carrying on the business, the length of the time of such business also should be there. Then the estimated amount of preliminary expenses, basic expenses and all should be mentioned very clearly. Name and address of the auditors, bankers and all should be there. Time and place where copies of balance sheets, then profit and loss account and auditor. See, when you just want to see about the when you just see the profit and loss account, it's very clearly understood that whether we got the profit or loss, isn't it? With that only, it's very clearly available for the investor, so that they will have a decision that whether they want to invest or not. The auditor's report so submitted must deal with the profit and loss of the company for each year of 5 financial years. So that must also be attached with the prospectus. If any profit or reserve has been capitalized, even if any of the profit is taken as a capitalization, even that particulars must also be stated in your prospectus. So with this lesson gets over. Okay, so we have learned so many terms about company, like how it is formed, then what are the types of company, advantages, disadvantages, features of a company, then Memorandum of Association, Article of Association, Prospectus. This lesson is very, very important lesson, children. Please read this lesson line by line. So if you have any doubts, you can come back to me for the live session and you can ask me the doubts. Please write your doubts in a paper and have it. So when I come for the live, you can ask me the doubts. I'll clear your doubts for sure. So as much as possible, please try to come for online classes. Okay, so be safe at home. So thank you, students.